Welcome to the second of 3 videos that PeakCare has produced for the Bill's Consultation Network. Our first video provided a brief overview of the 3 new child protection bills that placed its focus on the Family and Child Commission Bill. This video will focus on the Public Guardian Bill. A third video that will follow soon is one that focuses on the Child Protection Reform Amendment Bill. We'll now turn our attention to the Public Guardian Bill and look at some of the major features of this bill. The bill refocuses the role of the child guardian, as previously administered by the former Commission for Children, Young People and Child Guardian, by combining the child guardian aspects of the role with the existing adult guardian role to form a single Office of the Public Guardian, an independent statutory body that will report to the Attorney General and Minister for Justice. The role of the child guardian will operate primarily from statewide advocacy hubs and assume responsibilities broadly for overseeing the Community Visitors Program for children in out-of-home care, youth detention, corrective services facilities, as well as mental health facilities. The bill stipulates some major functions that will be undertaken by the Public Guardian. These functions are divided into 2 streams. There are the set of functions relating to adults with impaired capacity. The second stream of functions relate to, firstly, children who are subject to orders, agreements or interventions under the Child Protection Act, who are referred to within the bill as relevant children. And secondly, children living in visitable sites, which are listed within the bill. These visible sites include residential care facilities, detention centres, boot camps, corrective services facilities and mental health facilities. Some of the major activities to be undertaken by the Public Guardian as listed within the bill include providing general information and support to children and young people, the monitoring of plans, advocacy, mediation, and a role in intervening, potentially, in courts, tribunals and conferences in relation to these relevant children. Importantly, the bill also notes that the Public Guardian may continue to assist young people who are transitioning from being subject to an order, agreement or intervention after the child has turned 18 if the child is asking for this help. The bill stipulates that the focus of the child guardian activities is to be placed on individual advocacy and promoting the rights, interests and well-being of children, with the best interests of children being the paramount consideration. The following are some key provisions noted within the bill. The bill notes that child advocates must take into account the views and wishes of the child having regard to their age and maturity. The Public Guardian will have an ability to obtain and disclose confidential information necessary to perform the functions of the child guardian and the Public Guardian. The bill also lists and names certain prescribed entities. These include government and non-government education providers, health services, child and family support services, the new Family and Child Commission, the Queensland Police Service, the Director of Public Prosecutions, Legal Aid, and the Department of Communities, Child Safety and Disability Services. The bill stipulates that these prescribed entities must comply with Public Guardian requests for information unless some exceptional circumstances apply. Some other provisions of the bill include the allowance given to the Public Guardian to support a child in all legal proceedings and also to support a child and participate in family group meetings, conferences and mediation. The bill also allows the Public Guardian to apply to the Queensland Civil Administrative Tribunal to have certain reviewable decisions reviewed. The bill describes the new regime for Community Visitor Program as 3-tiered. Within that first tier, the Public Guardian, via community visitors, must visit all children living in visitable sites, as recorded within the bill. At the second tier, the Public Guardian must visit all children at visitable sites or residing in visitable homes who request a visit. And thirdly, the Public Guardian may determine other children living in visitable homes who require visits, including the regularity and frequency of those visits. And the bill lists non-exhaustive factors that become the criteria by which the Public Guardian makes the determination that these children should be visited. The bill also includes provision for the use of technology to contact a child or someone else at a visitable location to carry out the functions of a community visitor. Importantly, the bill also stipulates the powers of entry to visit relevant children and enter visitable sites held by both community visitors as well as child advocates. This power of entry includes also, if necessary, visits that may occur under a warrant issued by a magistrate's court if entry to a site has been refused. PCAT would be very interested to know what aspects of this bill you're pleased about and why, what aspects of the bill you might be concerned about and why, and if you are concerned about some aspects of the bill, what changes you think should be made to address your concerns. You're reminded that a copy of the bill, the accompanying explanatory notes, and the Minister's introductory speech is available on the Health and Community Service Committee's inquiry page at the address that you will see on the screen.